Welcome, everyone. It is great to have you all here at this 4IP Council's webinar on freedom to operate analysis in the product development process. My name is Claudia Tapia. I'm the president of 4IP Council, and I will be your host today. As you may know, 4IP Council is a non-for-profit research organization focused on the link between IP and innovation. On our website, you can find plenty of free materials such as studies, guidelines, summaries of relevant papers, and recordings of webinars like the one today. We also produce easy-to-digest content, especially tailored for non-IP experts, SMEs, and startups. Our aim is to assist innovative startups and SMEs in learning how to use IP to grow their businesses. But as you will learn today, a freedom to operate analysis is key when developing an effective and efficient IP strategy. And today I feel very fortunate because we have with us experts with diverse backgrounds. And I would like to emphasize that our goal here is not to provide legal advice. Each case is unique and requires attention to its particular circumstances. However, we can benefit from experts sharing their personal thoughts and experiences with all of us on the matter, and I truly look forward to listening to what they have to say. And without further delay, it is my pleasure to introduce you to our panelists for today's webinar. First, we have Subodh Kumar, who is Intellectual Property Service Head at Tata Consultancy Services Limited, also known as TCS. He has the responsibility for execution TCS Global IP Protection Strategy and his learning consulting service teams for protection of IP and regulatory compliance. Dr. Igor Nikolic is a research fellow at the European University Institute. He specializes and writes in the areas of intellectual property rights, competition law, standardization patents, innovation and technical standardization, competition, and digital economy. Dr. Nikos Minas is a European patent attorney specializing in the field of information and communication technologies with emphasis in the AI, ML technology space. He holds a PhD in microelectronics from Newcastle University in UK and has extensive experience in handling IP legal matters, mainly patents, know-how, trademarks, and database rights. And then finally, Thomas Gaunt is a European, a UK chartered patent attorney who leads the intellectual property legal practice group at Lewis Silkin. He primarily handles mechanical, electrical, and software patents and European oppositions and infringement opinion work, as well as registered design filings, focusing on technical products. Before we start, a final remark for the audience, please do not hesitate to use the Q&A tool to submit your live questions. You can find it in the lower part of the screen. You can raise any questions you may have during the webinar, and the questions will be addressed as we see them. So let's start. I'm very excited. So what are we going to learn today? Maybe we can start with the very basics. What is freedom to operate, or as we know, FTO? Nikos, would you like to give it a try?
Sure, why not? First of all, thank you very much for organizing the session. FTO is an exciting subject, and it comes with many names. So some people know it as a freedom to operate, others call it right to use or clearance of a product. But in essence, what we are trying to understand is whether we have the ability to use and sell our products and solutions without infringing anyone else's IP rights. And this extends beyond patents. It goes to trademarks, designs, and so on. So it's something that needs to be in every company's mindset, especially if you are providing services and products and you are launching new products all the time. In essence, that's what it is, more or less.
Thank you. I think now it's more clear. Anybody else wants to add anything?
We all agree with that definition?
Yeah, just to add, and it's a great introduction, but to sort of depart from my lawyerly tendencies, the other thing I would say about freedom to operate is to embrace it as an opportunity. And it's an opportunity to work out what you can do. You know, very often with legal advice, you look at things that you can't do and things that are difficult, and it gives you a chance to assess what the market's out there. It gives you ideas about whether you need to take licenses or whether there are opportunities to design around, and we'll talk about that later. But view it very much as a positive opportunity to look about what you can do as well.
Excellent, because at the end is what we want, right? To be able to do things. So why is this freedom to operate, or the FTO, important in the product development process? Maybe Subodh, you'd like to give a try?
Yeah, a very, very important question, and I could answer it in 3 different facets. First, from the point of view of investment. So any product which is launched into the market involves investments. And these investments are quite sizable, huge, involves a lot of time, resources. So from a point of view of a business owner, first and foremost is the return on investment. And when return of investment is the question, I do not want any unforeseen risks. And I don't want to go and launch my product with any risks involved in it. So the risks involved, primarily arising out of IP infringement, is something which would add to my cost. So from a business angle, it would be investment, cost, and the risks involved. But let me give you a different perspective. Apart from this, is as a business owner, I also have a credibility in the market. And I want to give products to customers which are risk-free. So I don't want my customers to get into any kind of liabilities later on. And that would definitely be create a different perspective about the way I do business. So credibility is also at stake. Risk is at stake. Investment is at stake. So that makes FTO very, very important for me.
Indeed. Nikos, Tom, anything to add?
No, I think what Subodh actually said is it's correct, right? At the end of the day, you want to put a product out there that your customers can purchase, and of course your partners can be happy with. But I mean, it's interesting the perspective that Tom brought as well, because at the same time, I mean, you want to design products that they are new and innovative, right? That's how you are going to attract your customers. That's how you are going to get a new investment. So we always take the approach of 2 ways. Let's look at what we can and what we cannot do. But definitely valid points have been raised so far.
Mm-hmm.
Yeah, and just to sort of flesh that out a bit, because I think it is a really important point Nikos raises, is that, during the product development stage, you do have opportunities to change things and modify things. And that can be whether it's the design itself, but even things, for example, such as your supply chains, and it depends what the project is, but maybe by sourcing your supply, your component parts from a different source, you maybe avoid infringement. And that's why it can be a really helpful step. And it's exactly what Subodh summed up. It's all about the investment and market credibility. It's a really important feature of it.
Mm-hmm. But now imagine we want to do the FTO. I'm convinced now that is very important. What is the best moment to conduct an FTO analysis? Tom?
Well, I think the best moment, it really does depend, and now I'm going to sound like a lawyer, it really does depend on your budget. If you do it early, it allows time for modifications, and it allows you to think about the product that you're developing and make adjustments. But at that point, you don't have much clarity about what you're actually making. So it's always a guess, and you've added an extra layer of kind of lack of clarity about whether you might or might not infringe something. If you do it at the end of the process, you have a really clear-cut definition of what you're making, and you can make a much stronger assessment about whether you infringe those risks. But at that point, it's often much further down the process. You've invested an awful lot. And so ideally with a budget, you do a little bit of both. You do a little bit of analysis at the start and much more significant analysis at the end. But often that isn't possible. And so it's really a judgment call about understanding the market and getting specialist advice. And it's a really difficult decision to make about where to spend that money.
Indeed. So what, Nikos, anyone?
Yeah, as Tom put it rightly, in the product life cycle, right from when the product is conceptualized till it released into the market, it goes through that life cycle process. As he put it rightly, it would either when you are at a conceptual stage, I'm not just repeating his point, but what is important and what I wanted to say differently here is that apart from deciding which is the best moment, which is again very clearly mentioned by Tom, I would look at it more as a culture, a practice of looking at outside in view of how your IP is, or potentially your IP is coming closer or infringing on any third party intellectual property. So if that is a kind of a practice and a culture, it would definitely enhance the robustness of the product development process. So it has to be well integrated into the life cycle and into the product development cycle. And of course, the best moments, as Tom has mentioned, could be these mix and match of those. But looking at it a little differently would be more of a culture and best practices that whatever you add new features in the product life cycle. Some are conceptualized, some are not conceptualized. It goes through that life cycle. So always, whenever you bring in IP, make sure you look at outside in view and make sure your development process is rigorous enough not to contaminate with any third party IP.
Good advice. Nikos?
I think what I would add, definitely you need to have some definition of the product. Looking at the freedom to operate is different than looking, for example, on patent landscape or a patentability advice. It's all about having a good definition of your product. Now, should you wait until you have the end product ready to ship? Probably not. It's not the right moment to do for you the FTO. So somewhere in between your conceptual and commercialization process, depending on your unique situation, because not all situations are the same. But when you have a first idea, then maybe that's the right moment to check what else is out there. What am I doing? Can I adapt my product? And maybe you can think of, now we're talking about adaptation, think of it from the beginning. You need to have an idea. What if something doesn't work? Would I be able to adapt my product? Would I be able to change my suppliers, my supply chain? So all this needs to be taken into account. It is not necessarily about IP. Sometimes it's about business relationship as well.
I see. So what I'm hearing from you is that it really depends on the situations and they are more relevant to be considered. But because you were talking about patent landscape being something different, I'm not sure if everybody here understands what a patent landscape and when.
Yeah. Maybe I can expand a little bit on that, but a patent landscape is where you are trying to enter, let's say, a new space, and you are looking to see who else is operating in that space and what kind of technologies are really being involved through, for example, patents. You do it mostly in the conceptual stage, to understand, okay, is there any gaps in the market that I can go and latch into, or has the market been saturated with all these new solutions, so there is no space for me to enter? This is what we mean by patent landscape. But freedom to operate is something very specific. We're looking at the claims, the scope of the claims. We're looking at the particular product and the jurisdiction. Let's don't forget that.
That's a lot of work. So having talked to some startups and SMEs, the message I usually get is, well, this is great, but what about money? Because this costs money. So what are the costs? I understand the more countries, probably the more expensive, but how much it usually costs to do FTO analysis? Tom? You're gonna tell me, depends. I've seen it already.
But it really does, and the it's one of the challenges about quoting for FTO analysis is that actually until you start it, you don't know. You could probably take a prediction, but it's really hard to sort of determine how many documents sort of come out of it, and what it comes down to is what are you trying to achieve, and also a little bit about what the product is. Are you talking about a single product that sort of embodies a quite tight concept, or are you talking about a product that's assembled from a number of features? And Subodh mentioned it earlier. Often these complex products, and particularly in the electronics sector, have got an accumulation of various different things, and that could be from functionality, patents, to process of manufacture, and all of that. And as each one of those expands, it's effectively an independent search. And I think that then you have to think about how many documents are coming out of that search and whether you're reviewing them. The moment you get a patent attorney and you ask a patent attorney to review a document, you're saying, okay, we're going to spend it's a 10-page patent, 15-page patent, that's going to take half an hour, and you can get these searches back sometimes, and they could have 60, 100, 200 patents. And so some judgment calls and balances of risk need to be made, and they aren't easy decisions. Now, having said all that, I appreciate that that's a sort of cop-out answer. So I want to kind of give some numbers to give people like kind of some ballparks. And what we would typically say is for a relatively straightforward mechanical invention, something that's sort of understood, and as Nikos alluded to, you can write a really nice, tight definition of the concept. You're probably looking at around £5,000 in total to do an analysis. So that would be a proportion for the searching and then a proportion for the subsequent analysis. Now, what might happen is you could say we could reduce that by focusing on particular competitors. So say you knew your primary competitor in the market was a particular company, so you look at their assets. And you could also focus it geographically. So you could say, I'm only interested in the US market, or I'm only interested in the European market, and that can help tighten it down. However, that would really probably be the starting point, and there would be a number of iterations beyond there. And this is where, once you've done that preliminary analysis, that's given you quite a high level viewpoint, you're probably going to have to go in and look at those patents in a lot more detail and find out relevance, and that would be quite high level. So for a proper full freedom to operate, you're probably looking at a budget starting at sort of £10,000, 10,000 euros, something like that, to get something meaningful. And actually, the reality is it could be a lot higher. Now, whether it's worth spending that, again, is a judgment call. And that's that's one of the other thing. And that comes to what the product is and what the market is and what the challenges would be if you encountered infringement. So it's without wishing to avoid the question entirely, it's quite a difficult question to answer.
That's okay. We will talk about the risks. But before we move to the next question, anything to add at this stage?
What I would say, definitely you cannot define the cost, but looking from the perspective of a startup or an SME, I think you should define a budget. And you say, I am comfortable of spending X amount of money on doing this, because it doesn't really matter. You could be doing it forever, a freedom to operate. It never stops. It's a continuous process if that's what you want to do. But if you define a budget, then it brings it into perspective. And you say, I allow myself to take a certain risk, but I have at least done some work to minimize that particular risk.
Makes absolutely sense. And Now I'm imagining this startup or SMEs looking in the market, trying to find the right expert. We know sometimes we have all kind of people in the market. What do you think they should be looking at? What kind of skills and expertise should have the expert that they need to do the FTO analysis? Subodh?
Yeah. See, the complexity of the FTO process would require cross-functional skills, I would say. And that cross-functional skills would mean, first of all, technological understanding the product, features, functionality in whichever domain you're operating. So that is very important for any assessment. And then you need those analytical skills to be able to translate that knowledge and ability to search the relevant patents. Okay, so that requires search skills, analytical skills for sure. And then when you analyze, you have to also look at what it means when it comes to a claim infringement. So there again, your legal acumen, and these are done by experts. These are done by lawyers too, when it comes to giving opinions on whether that particular product has freedom to freedom to operate at all. So if you look at, this is not done by one individual, it is done by a cross-functional team, which will have product experts, technology experts, patent specialists, and finally a legal attorney who is expert in that particular geography. So this is a combination. And in larger organizations, you definitely have cross-functional teams, but smaller organizations, yes, I understand. They have to really definitely rely on experts outside. And as Tom put in, it does cost. It does cost for the expertise, for the effort, and for the time. But those are the skills I can quickly recall, Claudia.
Makes sense. I mean, it's a difficult exercise. Otherwise, we will not require external expertise. And I hear you, there's a combination of skills which are needed, and that's why you usually have also different backgrounds. But if I have a tight budget, which countries should I prioritize? Nikos?
That's a good question. And you have a tight budget, so you cannot go everywhere. And then again, you have to think about it. Do I have to go everywhere? Do I care? Right? So the best thing to do is to look at your main markets. What is your project going to be commercialized? Is it the US, Europe? In which countries in Europe? Would you go to Asia? And then based on that, you need to start thinking about your FTO. So for example, I mean, you can be assured that if you find something relevant in the US, probably the chances are that they have a counterpart in Europe or China. That's how it goes, globalization. So I think try to go step by step, rather than take it all at once. Go step by step. You start with the most important countries that you want to commercialize the product. You think what is there, and then you decide, okay, should I go to the next step? And the next country, and so on.
Mm-hmm. Everybody nodding? 1812?
I think, yeah, Nikos sums it up brilliantly. It is really thinking about viewing it as a sort of incremental step. And if you look at, for example, the markets with the greatest commercial potential for your products, it helps you sort of refine down those priorities, because, you know, if ultimately you can't, if there's a knockout in one of those territories, you're probably going to have to modify the design anyway. So if you knock out Europe or you knock out the US markets or Asia, if that's your main markets, I think that's really important. Also, Nikos made a really good point about where big businesses, particularly big businesses, protect their innovation, or even any business really. There is a sort of, the reality is there is a hierarchy of territorial protection, and typically US is very high up that hierarchy. Europe is very high up that hierarchy. And so even if your opening market was a smaller country, you might decide, look, I'm going to focus on the US because I know people are going to file patents there. Sector also plays a role. And the reason it plays a role is because there are countries that are very innovative in particular areas. So you might think about Japan for biotech innovation or particular sorts of electronics, and the same with China. So it may be that you focus your search there. And then just to loop back to the previous question, which sort of Subodh made a really good point about thinking about that, selecting the right people. That can influence where you direct, who you use, because you're thinking about those where your market. So it is all linked together, and having an overall strategy or approach is really important.
Mm-hmm. Great. Now imagine we come to start doing the FTO analysis. What are the steps involved in conducting an FTO analysis? Who would like to share?
I'm happy to start, and you know, there's a lot of detail for it, so I'll rely on my co-panelists to help fill in the gaps that I skip. And Nikos mentioned this earlier, and it's really important, is to really work out the scope of what you're searching for. And there's two parts of that. One is defining what you're actually searching as your freedom to operate. Is it is it the product? Is it all the parts of the product? Is it the process that makes the product, including that? Trying to write a definition that will form the basis where you conduct the search, and then thinking about the geography, and also whether you're looking anyone filing patents in the area or your competitors. So once you've defined your scope, normally, well, there are different approaches. I mean, it would either way, you're going to probably instruct a searcher, whether it's within your organization or an external searcher, and they are going to do the sort of legwork at trying to distill that down into a meaningful starting point for your analysis. Now, what I would say is it's a really important step, because the cheaper the search, you'll be surprised the more documents you get and that you have to review. And so, and what I mean by that is sometimes it's worth paying for a really high quality search because you'll get less documents, but the quality will be higher. Then once you've got that search, then there's a sort of first step of reviewing. So in that review step, typically a patent attorney will review those patents and patent applications that are identified in the search, and look at potential for risks. Now, there are different approaches for this, but we would normally categorize those. So you kind of no risk, potential for risk, or clear high risk cases. The potential for risk will be cases where perhaps the claims aren't currently a worry, but there's something in the disclosure that worries you, and so you have to start thinking about, could they file divisionals and things like that? And that's we're starting to get into a sort of complex area. High risk will be things that you really want to analyze. And then once you've got that kind of short list, then you have to go and validate that data and work out, are the patents in force? Have renewal fees been paid? Where is the territorial protection? Are there correspondings? Are there divisionals? And then you're starting to then distill that down into a report that summarizes the position. And so it's very much a stepped process where you start off with this big list and you refine that down into the sort of really salient points, the really key applications that you want to do an investigation of. And at that point, you're really starting to understand how much freedom you have in your freedom to operate.
Wow. Anything to add? It sounds kind of a complex process, and the first thing comes to my mind is duration. How long does it take to conduct an FTO analysis? Maybe Subodh?
Yeah, as Tom has clearly explained, the scoping, the analysis, the due diligence, the scrutiny with the experts, then relevant patents, claim mapping, and legal views, and so on. So, it depends on the complexity of the product, and it depends on the number of geographies you are intending to do this analysis. So I would put it from my own experience, it would take anything between 4 to 8 weeks, depending on the complexity of the product and the amount of work and the geography. And that's the best estimation I can put. Maybe it will be different for different sectors.
I see faces nodding. Anything to add?
I mean, I think that's absolutely right. But with all things, you can, you can spend a little more and get things accelerated. That isn't necessarily the best thing to do, because, it is a hugely complicated process. And the quicker you try and rush things through, you're not necessarily picking up on things, shortcuts being made. So I think the time frame is accurate. I have seen them done quicker than that. It's not necessarily what you want to do, but it can be, but not a lot quicker. It is a long process. We'd normally expect the searcher for a simple mechanical invention, you're paying for a searcher to spend 4 or 5 days searching it. Now, they may use AI tools, they may use enhanced searching that speeds that up, but there are limits. So yeah, it's not a quick process.
You're talking about the AI tools, and first thing I'm thinking is about, I see, for example, the European Patent Office using it increasingly. Is it something that you find it in every office that is doing an FTO analysis, like consultancies, or is it something that you see some of them using and some others?
I think the comment about the AI tool is, and it sort of highlights the complexity of the freedom to operate analysis is. So when you conduct freedom to operate, you're probably focused on your own sector. But the reality is that there may be patents in other sectors that are relevant to what you're doing. And it particularly happens with, process manufacturing patents, but it can happen in any sector. And what AI-assisted searching can sometimes help with is pick up those random documents that may have accidentally infringed. Now, the risk of infringement actually resulting in litigation may be lower because the owner of that patent may operate in another area. But there are non-practicing entities that specialized in this field. They are, I'm aware of AI tools that work the other way, which is there is AI tools available which allow patent owners to search for products across any sector and identify when potential infringement or occurs to generate licensing revenue. So you do have to be wary, and so the addition of AI searching is just to enhance the search and try and pick up on those extra documents and deal with things, for example, features of the product described differently by different people, and AI can help pick that up.
Great. We have here a couple of questions also from the audience, so I'm gonna read them with your permission. How do you handle patent applications you find during your FTO search that have a very negative ISR and, according to the examiner, lack novelty and inventive steps? What is the best way to deal with those applications? Again, no legal advice, thoughts that you may have on this situation.
Sorry, I wanted to jump in. Nikos will as well. This is a really excellent question. And it highlights the level of analysis you need to go to, because once you discover a patent that's in a potential risk, it may not be valid, and in the case of applications, there may be a very negative outlook. Now, that can be helpful for you, and what you tend to do with really good FTO analysis is reach through and start looking at those documents that are cited in the search report and start building your own picture about what they're likely to come away with protection. The other thing it allows you to do is, and this is this is why it's so relevant in product development, is you know that that older prior art, that might be clear to use, that might be over, the patents are expired, it might be over 20 years. So if you can modify your design to be closer to that prior art that's cited against you, it greatly diminishes your infringement risk. So it's a really good question. And the answer is you have to look at it all.
Yeah, definitely. Just to add to that, I think Tom basically, summed it up very nicely. In any case, you have to consider it. If the patent is out there, it has not been withdrawn, it's not abandoned, it's an alive asset. And we all know as patent attorneys that, okay, just because the examiner provides an opinion that's negative doesn't mean that the patent will not get granted. So you have to think about it at a risk level. What is the risk of this patent getting granted with the scope that will cause my product to be infringed? And this is how you should look at it. But definitely, we should take it into account.
Very important point. Before we were talking about risks of not conducting FTO analysis, but we didn't go into the details. So maybe Subodh, maybe Igor, thoughts?
Yeah, certainly. See, this I covered in the earlier question itself. The risks of not conducting an FTO analysis. I would broadly classify under commercial risk, legal risk, and risk to the brand image. The commercial risk is your product not getting through, and facing a lot of litigations down the line. And legal risk would be that you have to defend all those suits which are filed against you for any potential infringement. Third is about the credibility as a business. You do not want to go to the market and make your customers liable for any third-party infringement. So these are the three primary risks which I can think of when it comes to the question of the risks of not conducting an FTO analysis.
Mm-hmm.
And if I may to add, so from a legal perspective, of course, the risk is being involved in patent infringement and getting an injunction, stopping the sale of your products. So that's a big risk. However, there is one, I would say, uniqueness. If you are using a product which uses internationally standardized technology, for example, you're using Wi-Fi connectivity or Bluetooth connection. So these standards are available typically. Patent owners give commitment to license them on fair, reasonable, and non-discriminatory terms. So it may happen that you launch your product without doing the freedom to operate analysis. But if you are being sued for the use of standard, then the patent owner has to offer you a license. So at least you will be assured that you will not be excluded from the market if you take a license. So there will be a license in place. So this is one uniqueness that makes it easier to launch products that use standards.
Mm-hmm. So we are talking, if I wrap up, so if we're talking about certain standards, like for example, cellular standards 2G to 5G, which is happening very often now with all this connectivity being incorporated in all kind of products, services, and processes, you have basically access from day one to the technology, but then you have to also commit or be able to pay for that technology that you are using, fair, reasonable, and non-discriminatory terms and conditions. Mm-hmm. Okay, but then I have all this risk. If we take out also these standard essential patents and focus more in the other implementation patterns, how can I minimize those infringement risks? Nikos?
Yeah, okay. How do you minimize the risk infringement? Okay. First of all, we did the freedom to operate. You cannot have freedom to operate by design, so you have to look for it. You need to come up with something, and then you have to decide what is the risk. But there are ways. I mean, so first of all, okay, once you have your first product and you have a negative, let's say, analysis, think about doing workarounds. See if your product allows that. Or alternatively, you will assess your risk of your organization. Can I take this risk ahead? Who is the owner of the patent that I'm looking for? Is it a litigious party? Can I reach an agreement? Do I have insurance that if I commercialize my product in a specific jurisdiction will allow me to at least navigate that that storm? So I would say you can personally, talking about minimizing risk, it's all about relative to what kind of analysis you received, but you cannot eliminate risk. Risk will always be there. Even when you have a clean, let's say, freedom to operate, it's only clean because you did not discover a document. Doesn't mean that someone else might not enforce a patent against you. So I would say it's all about the risk appetite of the organization and what we consider risk. I mean, we are operating in an environment, there are risks. It's one of those things.
Mm-hmm.
And if I may, another way to minimize risk, if the freedom to operate analysis uncovered the really blocking patent, maybe you can then go further and look, can you invalidate the patent? Can you do that sort of analysis and see how the patent is strong? And then you take a decision, are you going to risk and go to the market and try maybe to invalidate the patent? And another strategy maybe, depending on the company, if a company already has a portfolio of patents, and maybe you can sue the other company for infringement, and then you can cross-license each other's portfolio. So that's another strategy how you can minimize the risk.
Mm-hmm. Makes absolutely sense. Anything else?
Yeah, I was just going to add, I mean, they're both excellent points. There are a couple more, I'd add them. One is that just conducting the freedom to operate has a certain extent of minimizing your risk because, particularly jurisdictions that have punitive damages, by showing that you've conducted a serious and competent freedom to operate, you can demonstrate that you haven't willfully infringed a patent. So you've done your best to avoid infringement. And therefore, if there were a litigation, the level of damages can be minimized. And that's a really important point to remember. You know, as Nikos says, you're not going to avoid risk entirely, but what you can do is by taking this action, show that you've acted in good faith and done your best to sort of minimize that risk. The other point is, and it's a very good one, is thinking about, you know, can you license patents? Can you license patents from other entities to sort of protect your, you know, both owners of patents, but leaning towards designs that you can license, thinking about supply chains, and modifying those. So there are lots of steps. And really the point of the freedom to operate analysis is to give you lots of information so you understand really the kind of landscape that you're entering into, and allow you to make judgment calls about aspects of your design, who you buy from, where you get warranties for certain components that go into your product, things like that. But even conducting freedom to operate is a really important step to minimize those risks.
Makes absolutely sense. Regina, now the questions keep coming. One of them is, how do I balance the need for freedom to operate with the importance of respecting the IPR policy, the intellectual property rights of others? I'm a little bit confused with the question, I have to confess, because I think especially we conducted the freedom to operate in order to respect others.
By definition, you are respecting actually others by conducting the freedom to operate.
Right. So I think this basically we can compile the same answers from the former question and to see that you can respect, you can ask for a license, you can see if the other company is also infringing, in which case you may wish to have a cross license. I mean, there are a lot of possibilities that we have heard before. So I'm going to move to the next question, which is, how do international IP laws and regulations affect freedom to operate? And what are some key considerations when conducting an analysis in a global market? So 2 things. It's about IP laws and regulations. How do they affect? How do they impact freedom to operate? And second, which are the key considerations when you're conducting analysis globally? Who would like to take?
It's a really great question, and actually it could be its own seminar. I think there's quite a lot of considerations, and I'll think of a couple. One is to think about how infringement's assessed in different territories. There is in a number of territories now, there's a doctrine of equivalence. So when you assess your patent claims and potential infringement, you're no longer saying, does it fall within the literal meaning of the scope of the claims? You're now having to make judgment calls about what the core inventive concept is. There's other complications in other territories. For example, in the US, you can have a patent reissue. So there is the potential for broadening claim scope after grant. That can be a really difficult thing to make judgment calls about whether you infringe or not. So it is a really complicated area, and there is no sort of simple answer. And again, it's a sort of balance of risk and trying to make a sort of judgment call about levels of risk that you're comfortable with.
One thing I will add actually as well, we have the prosecution history estoppel as well. What have you said during the prosecution that might harm, for example, the validity of a patent or the enforcement of a patent?
Important element to consider, definitely. We were talking about the limitations regarding budget. So if you have less budget and less possibilities, is there any other limitations regarding the FTO analysis that we need to consider?
Yeah. So you have to, I think some of the limitations did come out in a very nice way. I think Nicholas and Tom has put it that look at FTO as something which can minimize or mitigate risk. It's not zero risk. So any product owner, when he goes into the market, that calculated risk is always there. You can't go to the market with zero risk. And developing it a little further, and if you look at, I'm talking from a perspective of information technology sector, where the advancements are very fast, information innovations are very fast paced. Now, let me first talk about patent infringement. If I'm looking at it, freedom to operate from a patent infringement point of view, whatever information I have on patents will be 18 months old. Otherwise, I would not even know that a patent is filed because that's the publication time. And rest of the information is all non-patent literature, either written in papers, but you don't really get that the patents which are filed in less than 18 months. So definitely we'll have to keep that in mind when we do an FTO analysis, that we'll have to periodically have alerts, updates on what are those relevant patents which are getting added over a period of time. So if I can put that as a limitation, yes, but I do consider that as a limitation, especially when it comes to analyzing patent infringement. And also the fast-paced technologies, where today you talk about AI-related applications, products which are significantly leveraging the algorithms and the AI capability. So somewhere down the line, we don't get those information very clearly through the patents. So I may position this as one of the limitations, to the best of my understanding.
Let's see. Maybe we can move to the next question because I'm seeing so many questions coming. How can I effectively communicate the results of a freedom to operate analysis to its stakeholders within my organization? And how can I ensure that everybody is aligned on the best way forward?
Yeah, you can take that. And that is a very good question and a very challenging one also, because all along we have been discussing about risks, risk mitigation. But when an interesting point came up when Igor spoke about opportunities, licensing opportunities. So if you ask me, the best way or the best communication is not just look at threats, because I wouldn't want to be be completely on that defensive mode. Rather, in the entire freedom to operate analysis, let me also see the opportunities. Opportunities, as he rightly mentioned, for licensing, opportunities in the entire landscape where to create patents. And at the same time, it's a very important moment to do a lot of introspection on the strengths and weaknesses of the product also, because you get to know a lot of information in the market, both through your analysis and also through your sales, marketing, research, and innovation team. So I would say the best communication, the way to communicate an outcome, an FTO, I would rather put it in a strength, weakness, opportunities, threat kind of analysis, and look at the positivity more and opportunities more, so that your product can go into the market with more confidence. Finally, a product manager or a product owner would need more confidence than being intimated by any potential risk. I think I'm looking at that as the best way of communicating the results of an FTO.
Focusing on the positive. I like that. Anything else to add?
What I would add is that you need to communicate the summary and how it affects the product that you are launching to your stakeholders. When you're talking about C-level executives, freedom to operate is not exactly in the front of their mind. Okay, it's a problem for them. I mean, so yes, I agree. You should really look at the positives, but at the end of the day, they want to understand. Okay, can I launch this product right now? What is my loss? And once you have that, and you communicate clearly what is the risk and what are the strategies that you want to put forward to mitigate those risks, which could include also developing our own patent portfolio, licensing opportunities, and so on, then you have a winning strategy, because this is where your C-level executives will buy and say, okay, that's fair enough. We have a bit of risk. We have accepted it. Let's move forward with your mitigation strategy plan.
Mm-hmm. Here I have another question. How can I leverage freedom to operate analysis to gain a competitive advantage in my industry? And what are some best practices for doing so?
It's a really interesting question, and it's sort of, without talking about specific cases, it can be quite difficult. But I think things to think about are, maybe you realize quite quickly that, most players in the market are paying a license fee to a particular entity. And maybe that understanding allows you to avoid the need to pay that license fee by designing around it, and so that could give you a competitive advantage in terms of cost. And you have to remember, with a product there may be more than one patent covering it. So if you can find opportunities to avoid paying royalty rates on particular aspects of the invention, you can lower your cost compared to a lot of other competitors in the market. It really depends on the field. But it just gives you information, and that, for example, can include, for instance, those licensing negotiations that you subsequently have. As Igor mentioned, you might have your own assets to say, it gives you an opportunity to say, look, we've got a piece of technology, we can cross-license this with you if you give us a license for that. You may also have revealed, because your understanding of a particular technical area will be quite a high level after an FTO, you may have a conversation with that entity, say, look, we're a little bit suspicious about the validity of this patent, but we don't want to go into that, and maybe use that in your licensing negotiations. So it ultimately, with any IP negotiation, it comes out with you want a sort of an asymmetry of information. So the more you understand, and the less, or at least to put you on the par with the other entity you're talking to, gives you a really important standpoint, and that's another value of having really good FTO analysis.
But imagine that I receive my FTO analysis and it appears I'm infringing several patents. Are they all equally important? How do I identify whether something is more important or not? Igor, any ideas?
Well, if you are infringing, I would say then you would have to look at, is this something the core of your technology? Is it something that you can invent around the technology? I think that would be the first step. And the second would be, can you license those patents? Are they available for the licensing? Is the company having a policy of licensing? Or if it's a standard, then you know it's going to be licensed. And one thing that eases licensing, if you have patent pools. So you may look at, is this technology that I'm using in a pool? How do I access the pool? How much do I pay? And then there are other strategies, as we talked about mitigation of risks. Can you maybe validate patent? Do you have your own portfolio, which may use for cross-licensing? Is the company actively pursuing others for the infringement? That may also give you indication of will you be sued or not. So I think those are some strategies to use.
Thanks, Igor. The questions keep arriving, but unfortunately, it is now time to conclude. And I would like to thank you so much, Igor, Nikos, and Subodh, and Tom, for sharing your knowledge and expertise. But please don't leave yet, because first I want to thank you, all the audience, for attending the webinar, for sending your questions, participating. And a recording of this presentation, or better say, of this discussion, will be made available on For IP Council webinar tomorrow. And please don't forget to register to our upcoming webinar on the 5th, so next week, where we can learn about 3 very important initiatives, which are really focused to support SMEs in the EU regarding IP, and these are the initiatives from the EU IPO, very important for you to know. So strongly recommend you to come here. You will have time also to raise your questions, and you can find more in our website at foripcouncil.com. And I also believe Nikos would like to invite you all to the International Annual Conference from LESI before we go.
Right. Yes, thank you very much, Claudia, especially for bringing it up. Indeed, let me just see, do we have, yes, here we are. I think you can all see the slide. Yes, we do have the Licensing Executive Society International Conference. It's an annual thing. It happens in Montreal. So if you are around in Montreal, or if you are going, please, attend the sessions. It's an excellent way to network with licensing professionals, practitioners, companies, and would like to thank, on behalf of LESI, For IP, for organizing this particular session, for giving us the opportunity. And what I would say is that I am the co-chair of the Patent and Technology Licensing Committee. So if you are interested in joining one of the committees of LESI, send us a message. We would love to hear from you. And we are looking forward to seeing you all in Montreal if you're there.
That sounds like an amazing event. So I think definitely we should all consider. And thanks so much again. Finally, I would like to remind you all that tomorrow you will receive an email inviting you to complete a 1-minute survey about this webinar. We will be very grateful for your feedback. And with that, I would like to thank everyone and wish you a wonderful morning, afternoon, evening, depending where you are. Thanks, everyone. Bye-bye.